Impact. And in this series, we're discussing how the opinions and conclusions of the qualified medical evaluator affect two things. Number one, how the opinions and conclusions affect the financial condition of the examinee. And number two, how the QME's opinions and conclusions affect the financial condition of the workers' compensation system in the state of California. And with today's video, we're in session number 5. And in this series, we have reviewed several statistics from recently published studies. In fact, they were published in 2017 by both the RAND Corporation, which is based in Southern California, and also the WCIRB, the Workers' Compensation Insurance Rating Bureau, both of which have published very recent studies containing very recent facts, figures, and statistics that portray a glum picture for the California workers' compensation system. And the premise of this series is that the poor condition of the California workers' compensation system can be traced in large part, not completely of course, but in large part can be traced to the poor medical decision making of the qualified medical evaluator. And so far in this series, we've explained that poor medical decision making by the qualified medical evaluator in three main areas. That is causation, AOE-COE, permanent impairment ratings, and then also in the apportionment determination, has brought the California workers' compensation system to the precipice of a crisis, if you can believe that. And in our very last session, we started tackling the complex issue of AOE-COE. And we're talking about how you as the qualified medical evaluator can make a correct opinion on AOE-COE in every single case, almost as if you had a crystal ball. Now, a correct decision on AOE-COE, in other words, the AOE-COE determination is the portal of entry for examinees to either receive workers' compensation benefits or to be denied workers' compensation benefits. And we want injured workers who truly qualify and who truly deserve workers' compensation benefits. Of course, we want them to be admitted into the system so that they can receive the benefits that have been established for them. Similarly, examinees who do not qualify and who do not deserve workers' compensation benefits need to be prohibited from accessing those benefits. And that prohibition begins at the gateway or the portal of the AOE-COE determination, which is in your domain. And so we're talking about how is it possible that the qualified medical evaluator can make an accurate, correct, and truthful and actual determination on AOE-COE in every single case. Well, it turns out there's an exact science to providing your opinion on AOE-COE. And in the first session of this section, meaning the AOE-COE section of this program, we talked about how the AMA guides view examinees who come to the permanent impairment evaluation. And we cited several references from the AMA guides that tell us that a certain percentage of examinees who attend a permanent impairment evaluation may simply be persons seeking benefits for whom no permanent impairment actually exists. In other words, examinees can present to the permanent impairment evaluation in perfectly fine condition, but can malinger a condition in order to portray themselves to be in worse condition than they actually are so that they can obtain benefits. Well, similarly, and by analogy, examinees can present to the qualified medical evaluation in those cases that involved a denied claim and can malinger their condition in order to be allowed access to workers' compensation benefits at the beginning of a claim. This is where the AOE-COE determination is critical. So we set the stage for the philosophy of the AOE-COE determination by facing the hard fact that many examinees are not forthright and are not forthcoming, and we have to learn how to differentiate between sincere examinees and examinees who may be less than sincere. And so how do we do that? How do we do that? How can we assess our examinees' sincerity? Well, we began in our last session by talking about how to do such a thing in the face-to-face evaluation with your examinee. In other words, we discussed a series of strategies that relate to your communications, your interactive communication with the examinee during the face-to-face evaluation. So we want to continue with that discussion today, and then once we fully handled that discussion, I want to go into a final discussion related to the AOA-COE determination, and that is how to fashion and how to write your argument either for or against industrial injury so that it's truthful, so that it's accurate, and so that it's held up or upheld by the trier of fact in every single case. Because it does no good whatsoever to provide an opinion on AOE and COE if it's not upheld by the trier of fact. It's important that once you arrive at the correct determination, either for or against industrial injury, that you present that argument in such a way that it can be used by the trier of fact, because if it's formatted improperly and cannot be used by the trier of fact, your opinion cannot be upheld. So it's important that it be presented exactly perfectly, and I want to share with you in today's discussion how to do that. Okay, so that's where we're going today. So let's begin. In our last session, we started by reviewing a couple of recently published studies. Both of these studies were published in the Journal of Legal and Criminologic Psychology, and it has to do with interviewing techniques of our claimants. And interviewing techniques have been studied since the beginning of time. And it seems that in police and in forensic settings, there's an exact science for determining the credibility of, I guess you would refer to them as suspects. And you've probably seen portrayals of police interrogation techniques in popular series and in popular movies. And certainly these professionals have perfected their interviewing techniques to arrive quickly at the truth. Well, it seems that criminal and forensic interviewing techniques are now being applied in the insurance claims setting. Insurance claims settings, such as in workers' compensation insurance claims setting. And so we began by reviewing study number 1, which is entitled Exploiting Liars' Verbal Strategies by examining the verifiability of details. And then our second study is entitled Applying the Verifiability Approach to Insurance Claims Settings. So let's pick up where we left off with our last session. In our last session, we established that in face-to-face interviewing, liars are faced with a dilemma. They're faced with an information management dilemma. Truth tellers, on the other hand, are not faced with any such dilemma. Now, it seems that liars have to walk a tightrope between creating an honest and credible and favorable impression with the evaluator, which is us, on the one hand, and not raising suspicion or concern at the same time in the evaluator. So they have to walk a tightrope between providing just enough detail in their story, in their testimony, to convince the examiner of their credibility, but not providing too much detail that could raise suspicion. So liars come to the face-to-face evaluation with a strategy. And the purpose of our interviewing technique is to exploit that strategy by examining the details of their story. So we stated that liars' strategy involves avoiding mentioning details that can be verified. They avoid mentioning details that can be verified. So when you're in the face-to-face evaluation with your examinee and the examinee is explaining to you how the industrial injury occurred and how they reported that industrial injury to their manager or supervisor, and how that industrial injury didn't seem to be that significant at the beginning when it happened on a Friday, but over the weekend how the pain from that industrial injury worsened, and how by Monday morning they knew that they must seek medical treatment. And as they go through the details of their story, you're going to be listening acutely to the details to determine which of the details are details that can be verified. Isn't that interesting? It seems that truth tellers provide details that can be verified, whereas liars have a strategy. Their strategy involves avoiding mentioning details that can be verified. So why would liars avoid mentioning details that can be verified? Because a liar knows that if you were to take the time, effort, and energy to investigate those details, many of those details would be found to be unverifiable because they never actually happened. Okay? So, according to this study, exploiting liars' verbal strategies by examining the verifiability of details, they tell us that one of the most important of the verbal criteria that we rely on in assessing credibility is richness of details. Richness of details. It seems that the richer an account is perceived to be in detail, the richer the story is in detail, the more likely it is to be believed. So a liar is faced with providing enough detail for the story to appear to be credible, but they have to avoid mentioning details that could possibly be verified and found to be false. So, although providing details helps to generate an honest impression, it also puts liars at risk because investigators may be able to verify some of the details and often do so. So, when you're in the face-to-face evaluation with your examinee, you're looking and listening for the details. And when the examinee mentions details, you're asking yourself whether or not those details can be verified. And I'm going to give you an example of an actual case from my own archives that involves many, many details. The story involves many, many details, none of which could actually be verified. Okay? So we're focusing on richness of details, and of those details, which of those details can be verified. Truth tellers provide copious details, all of which can be verified, whereas liars provide copious details, most of which cannot be verified. Very, very interesting. And remember that Labor Code 3600, the basic rule for compensability evaluation is that the employee, the injured worker, has the burden of proof of establishing industrial injury, and they must establish the industrial injury by a preponderance of the evidence. So unfortunately, many, many examinees come to the face-to-face evaluation with no evidence. What is evidence? Evidence would include details that could be verified. So for example, an examinee will come to the face-to-face evaluation, and you as the examiner will ask the examinee, did you report the incident? Did you report the incident of injury? And the examinee will say things like, well, yes, I wrote it up and I put a note on my manager's desk. because I came to work before my manager, the injury happened an hour before my manager came to work. So my manager, who comes to work at 8 o'clock, usually gets his coffee, and then he sits down in his office and goes through his emails, and I set it right there on his desk so that he could see it. Now, do you notice that that story has many, many details? Some of those details can be verified. For example, it can be verified that the manager comes to work at 8. It can be verified that the manager, first thing he does when he gets to work is gets a cup of coffee. It can be verified that the first thing that the manager does when he sits down at his desk is he goes through his emails. Those are details that can be verified. But the note or the write-up of the document of the incident of injury cannot be verified. Cannot be verified. So you may ask the examinee, well, did you save a copy of the note? Did you make a copy of it for yourself? And the examinee will tell you, well, no, I did not. And the writing of the note and the reporting of an injury is a detail that cannot be verified, usually because it never happened. Examinees who write up their industrial injury and write a report to their supervisor will keep a proof of that, will keep a copy of that, will retain a carbon of that, and they can provide that to you in a copy, which is a detail that's easily verified. So you're looking for the verifiability of the details of the story of the injury as it occurred. Okay? Now, our second study is quite fascinating. It seems that the gap between truth tellers and liars opens up, and it becomes much, much easier to distinguish truth tellers from liars by employing a very simple strategy. And that's described in this study, which is called Applying the Verifiability Approach to Insurance Claims Settings, such as workers' compensation insurance claims. And it's entitled Exploring the Effect of the Information Protocol. The Information Protocol. Now, the Information Protocol involves informing the examinee, that's the information, you inform them, informing the examinee that you are going to require that they provide you as many details as they possibly can, and that number two, you as the examiner will be attempting to verify as many of those details as possible. So you may simply say to the examinee, Mr. Jones, I'm going to be asking you 100 questions about your injury and about the course of your workers' compensation claim, and I want you to provide for me as much detail in your responses as possible. Now, I have the entire medical records and administrative records here related to your claim. I want you to know that I'm going to be attempting to verify your story through the medical records. So I need you to be as accurate as possible in recollecting the details. Okay, do you understand? And you get a head nod from the examinee. Basically, informing the examinee that you're going to be checking on the verifiability of the details. This is called the verifiability approach. And it's found that liars provide many, many details. They provide credible testimony. They're sincere and they're passionate, and they provide many details. The main details that relate to the industrial injury you're going to find are details that cannot be verified. And so this gap, this quantity of unverifiable details becomes immeasurably greater when you advise them in advance that you're going to be checking on the verifiability of their details. Okay? So according to this particular study, When claimants are provided with the information protocol, meaning you tell them in advance that you're going to be checking the verifiability of their story, truth tellers provide more verifiable details in their claims than informed liars. Liars who were told that you're going to be checking the verifiability of the details. So when these claimants, insurance claimants, are informed that the examiner is going to be checking on the verifiability of the details, the truth tellers, it seems that they go through a mental exercise that says in their mind, okay, you're going to check on my details? And then they pour on. They pour on the details. They unload the details. They challenge the examiner to go ahead and verify these details because they know they're true. Now, this is where liars are faced with a dilemma. It seems that liars, because the details are unverifiable, the liars will withhold the details because they know that the details cannot be verified. Now, every once in a while, a liar will provide false, verifiable details. They will provide details that cannot be verified, but they challenge you as the examiner to go ahead and verify those details. That is what's called in the business, that's called bluffing. The examinee bluffs the examiner by challenging the examiner to go ahead and verify these details, even though the examinee knows that the details are false. That's called bluffing. Most examinees will simply withhold the details that cannot be verified, but some examinees may try to bluff you as the examiner, so you need to be aware that you may need to go ahead and attempt to check on the verifiability of their details. The information protocol facilitated increased lie detection accuracy in insurance claims settings. So this may be an approach that you want to employ with your examinees. You may just take a moment prior to the face-to-face evaluation and inform the examinee to provide you as many details as possible, but to be accurate with those details because you're going to be attempting to check upon the veracity or the truthfulness of those details, at least by reviewing the medical and administrative records that you've received, okay? And in this way, you will find very quickly which examinees are able to prove with a preponderance of the evidence their industrial injury and which examinees are simply attempting to obtain workers' compensation benefits by fabricating or fraudulating a claim for injury that never actually occurred, okay? And in this way, you can provide a correct determination on AOE-COE 100% of the time. It's an exact system, it's an exact formula, and it works every single time, okay? So, a couple conclusions from these studies, and I'll read these to you to help you more fully digest this concept, which I'm sure is coming to you newly for the first time, but which you're going to be hearing more and more about because this verifiability approach and interrogation techniques are being used more and more in the medical legal contexts. So, in conclusion, these studies tell us in legal, criminal, forensic, and now in insurance claims interviewing, truth tellers and liars can be distinguished by the amount of rich and verifiable detail that they offer. The gap between the two is magnified when the interviewer tells the interviewee in advance that they plan to verify all details to assess for credibility. This causes the truth tellers to pour on even more details, while the liars struggle because they cannot come up with details that can be verified, that is, without bluffing. Now, verifiability is based on the following. activities that are documented and therefore checkable. So for example, in forensic and criminal settings, this might involve phone calls, cash withdrawals from an ATM machine, etc. In the work comp setting, this amounts to an incident report, an accident report, a witness statement, photos, faxes, videotaping, really anything that the examinee brings to you to help verify their details helps their case and helps their credibility in their claim for an industrial injury, correct? Many times an examinee, you'll ask the examinee, well, was this incident witnessed? And the examinee will tell you, well, yes, it was witnessed by my coworker John. And you'll ask the examinee, well, do you have a witness statement from John? A witness statement from John. Now remember, the law requires that the employee prove the industrial injury with a preponderance of the evidence. Many of these examinees think that you have the burden to go ahead and get a witness statement from John if you want to prove the industrial injury. But the law says the burden of proof is on the employee to prove the industrial injury. It's not on you as the qualified medical evaluator to prove the industrial injury. It's on the employee to prove the industrial injury. So if the employee had a witness to the incident and the employee has the burden to prove the injury, do you think the employee should bring a statement from the witness if the witness actually witnessed the incident? But examinees will not bring a witness statement because in 99% of cases, the incident actually was not witnessed. It was an unwitnessed incident. Similarly, what about videotaping? I had an examinee recently tell me that if I wanted to see the industrial injury the way he described it to have occurred, I could just go ahead and get the videotaping because there's cameras all around the warehouse where he worked, and certainly he assumes that the video cameras had captured the industrial injury. I asked him, did you bring copies of the videotaping? Because the law requires the employee to prove the industrial injury, and the law requires that the employee prove the industrial injury by a preponderance of the evidence. So if the industrial injury occurred the way the examinee described it to have occurred, and if it was captured on videotaping the way he states it was captured, the burden to provide the videotaping is on the employee. So if the employee states that it was captured on video, the only way to verify that detail is to observe the videotaping. And it's up to the employee to bring the videotaping to the evaluation or to obtain the videotaping. Simply a report by the examinee that the injury was captured on videotaping is not a detail that can be verified unless the employee takes the time, effort, energy as required by law to verify that detail for us as the evaluators. Other criteria that qualify as verifiable details happens when the examinee says the injurious activities were carried out with another identifiable person, either injured or uninjured, who can be traced. This again relates to the so-called witness. In the work comp setting, this amounts to identifying a coworker who was involved in the incident who is willing to come forward with a written statement. And I know you've encountered examinees who will tell you that the incident was witnessed. Does that mean to you that the incident was witnessed? When an examinee tells you, oh yeah, the injury was witnessed by Betty, Lucy, and Sally, do you just accept that the injury was witnessed by Betty, Lucy, and Sally? Or do you require some sort of verifiability, some sort of verification of that detail? If the injury was witnessed by Betty, Lucy, and Sally, would it help to have a witness statement from Betty? Would it help to have a witness statement from Sally? How compelling would it be if you had witness statements from Betty, Lucy, and Sally? If the examinee took the time to verify those details for you, how compelling would that be? It would be very compelling, wouldn't it? And it would contribute to your opinion for FOR, industrial injury. When an examinee tells you that the incident was witnessed by Betty, Lucy, and Sally and fails to provide witness statements from either Betty, either Lucy, or either Sally, you can assume that the incident was unwitnessed. Okay? Now I'm going to share with you an actual case in just a minute here where in the examinee not only had no details to verify that industrial injury actually occurred, but there were statements, multiple statements, I believe 2 statements from co-workers and supervisors countering the examinee's account of the industrial injury. So not only did the examinee not provide verifiable detail, there was actual verifiable detail in opposition to the employee's story. How compelling is that in your argument against industrial causation? It's very, very compelling because those are details that can be verified, whereas the examinee provides no details that can be verified, okay? Similarly, incidences that are witnessed by at least one other identifiable and traceable person. In the work comp setting, this amounts to an unwitnessed incident. How about records by CCTV cameras? This could apply to the work comp setting, wherein many areas of businesses have video cameras. Details that do not meet at least one of these criteria are classified as unverifiable details. So let me share with you this actual case of an examinee that I saw approximately 6 to 9 months ago. We'll call this examinee Miss Clark. And this is her story, and this is extracted exactly from the report that I submitted related to Miss Clark. It says, according to Miss Clark, on June 26, 2016, she was at work doing her regular housekeeping duties. She explains that initially she was hired as a disabled worker because of a prior injury to her knees. Based on this, her employer provided her some accommodations to the typical work duties in order to be congenial with the knees. This modification involved a fewer number of rooms to clean per day than other coworkers who had normal knees, and more time allocated to clean each room. This is for an employee who works at a hotel in housekeeping and cleans the hotel rooms. So she was provided with fewer number of rooms to clean than her coworkers, and she was given more time to clean each room than her coworkers. So for the same pay as her coworkers, according to her, she was hired on a disabled status, and for the same pay, she could clean fewer rooms per day and have more time to clean each room than her other coworkers who were hired on regular status, according to Miss Clark. According to Miss Clark, the hotel was happy with her service in this capacity. However, when management changed, demands on her duties increased, and any consideration for her disability was forgotten. Okay? Now, in this first paragraph, which of these details are details that can be verified? Can we verify, or does she verify that initially she was hired as a disabled worker? No, that's an unverifiable detail. Do we know that because of this, her employer provided her some accommodations to the typical work duties in order to be congenial with her needs? Is this a detail that can be verified? No, it's not a detail that can be verified. She provides no verification that she was hired as a disabled worker. Can we verify that she was required to clean a fewer number of rooms and that she was allowed more time to clean each room based on her disabled status? No, these are unverifiable details. This is a compelling story, correct? However, these are details that cannot be verified. They're detailed. This story is detailed, but these are full of details that cannot be verified. According to Ms. Clark, the hotel was happy with her service in this capacity. Is this a detail that we can verify? No, it's not. When management changed, demands on her duties increased, and any consideration for her disability was forgotten. Is this a detail that we can verify? No. This story is chock full of unverifiable details, and it basically means nothing. On June 26, 2016, she was given extra rooms to clean, and she was advised to do them as quickly as possible. Is this a detail that can be verified? She brings no verification of this detail. This is strictly a subjective detail that cannot be verified. Suddenly, when making a bed, her back started hurting her. Can we verify that detail? How could we possibly verify that as a detail? It's an unverifiable detail. She continued working and pain intensified throughout the day to the point that she had difficulty breathing. She notified her supervisor of the situation and she went home. And I asked her, can you verify that you notified your supervisor of this? And of course, she could not provide any verification in the form of a written note, a incident report, a written statement. She had no verification that she notified her manager of the situation. The next morning, she advised her manager of the situation to advise the manager that her performance might be hampered because she was having pain. I asked her, do you have any verification that you advised your manager of this situation? And of course, she could provide no verification of it. She began her shift, but she was unable to continue. She filled out paperwork to receive medical treatment. And this is just an example, a simple example of examinee statements that are full of details that present a compelling story, that present an otherwise sincere story. However, on close examination of the details of the statement, you'll notice that of those details, most of those details cannot be verified. And so without verification, without the examinee proving with a preponderance of the evidence their industrial injury, it makes the determination on AOE COE quite simple. Okay? So this is a technique that you can use in the face-to-face interview and also in the physical examination with your examinee. You're looking for details that can be verified. When the examinee brings verifiable details, then the opinion for industrial injury, in support of industrial injury, is easy because it's easily verifiable that an industrial injury actually occurred. In the absence of details that can be verified, how can you possibly opine for industrial injury when you know that the incident more likely than not did not actually occur because none of the details associated with the statement as to how the injury occurred can be verified? This is an exact science, and this is an exact system that you can use with every single examinee. Now, I want to take a quick break while I get some new notes. And in our next discussion, we're going to talk about how to fashion and how to write your opinion either for or against industrial injury so that it's upheld by the trier of fact in every single case. So I look forward to being back with you here in just a very few moments as we continue our ongoing discussion entitled QME's Financial Impact. So I'll be back with you here in just a very few moments. Your AOE COE determination within the body of your QME report so that it's upheld by the trier of fact. So we're talking about an examinee who provides copious details regarding the industrial injury, but upon close inspection of those details, it's quite apparent that none of the details can be verified. The story is full of unverifiable details. Well, it's interesting. One thing that could be verified in relation to this particular case, and this is an actual case, were some statements from managers and supervisors to contradict the examinee's story. So let me just read from the body of the QME report some of these statements. So Ms. Clark's statement of her injury contradicts supervisor statements which describe symptoms not with the back, but symptoms with the knees. Remember, the examinee is reporting an industrial injury to her back, which occurred when she was forced to overwork and clean too many rooms too quickly for her knees, because she was hired as a disabled worker because of prior injury to her knees. So here's what the general managers and assistant supervisors have to say about the injury to the back compared to the situation with the knees. So here's a statement from the general manager. States, on Monday, June 27, Ms. Clark reported in the morning to the general manager that her knee was hurting. Okay, so the examinee is reporting an injury to her back. But here, this general manager is stating in writing that Ms. Clark reported that her knees were hurting. The general manager offered to send Ms. Clark to a doctor to get checked out. However, Ms. Clark stated that it happened at Target store before starting to work here at the hotel. She mentioned that her knees always hurt. In fact, it started when she broke her knee when she was in school. Then her knee was fine. When she worked at Target store, she hurt it when she was in stocking. She had a claim with Target. Well, on this particular day, she refused going to a doctor as she sees a doctor already for the knee. So it seems that Ms. Clark was informing management that the work pace of cleaning too many rooms too quickly was aggravating her knees. And remember, she was hired on a disabled status because of her bad knees. So it seems that the real motive behind reporting injury is to reduce the number of work and reduce the number of rooms required to be cleaned. She refused going to a doctor as she sees a doctor already for the knee. Later in the afternoon, she told management that her knee was hurting. She was told to go home. She was in pain, but she refused. When filling out an incident report in the general manager's office to get authorization form to go see a doctor, she asked if she should put down yesterday's date. Then she mentions her back has been hurting since yesterday. Ms. Clark said her knee will always hurt and she sees enough doctors for that injury, and she did not mention anything about her back in the morning. So it seems that the employee is mentioning injury to her back in retrospect, when initially she was complaining about pain in her knees, and this is simply an attempt to fabricate a claim for a new body part in protest to being required to clean the normal number of rooms that every other employee is required to clean. Here's a statement from the assistant general manager. The supervisor and I both decided that based on the number of rooms that Miss Clark had cleaned, which is a reduced number of rooms, and her stating that she was hurting, we decided to send her home. When I approached Miss Clark, she stated that she was hurting from her previous surgeries she had received before she had been hired. Those were surgery to her knees. She stated she had taken some pain medication and that she was good to finish her work. Never in our conversation did she mention that her back was hurt. So in this case, the examinee provides details regarding an injury to her back and her reporting of that injury to her supervisors, none of which can be verified. But in contrast to that, we have actual verification in the form of written statements from a supervisor and from a general manager to a contrary story. So how compelling is the case for industrial injury in this case? Not very compelling at all. How compelling is the case or the argument against industrial injury in this case? It's quite a bit stronger than is the case for industrial injury. And in this case, based on the verifiability of details, I opined against industrial injury because it seemed to me that the examinee, Ms. Clark, was simply job dissatisfied. She was unhappy with being pushed at work, and she was not happy with the requirement of the number of rooms that she was required to clean, and she was protesting this requirement. So let's turn our attention now to how to write up this argument. When you have an argument either for industrial injury and you support the examinee for industrial injury, or you have an opinion against industrial injury and you want to prohibit the examinee from obtaining workers' compensation benefits, how do you write up that argument so that it's supported by the trier of fact? So let's spend just a few moments talking here about your AOE, COE determination. Now remember, AOE refers to arising out of employment, and COE refers to occurring in the course of employment. And both of those conditions have to be met in order to qualify for an industrial injury. Well, of those two, AOE and COE, the qualified medical evaluator opines on AOE, not on COE. And this is clearly stated in the 2016 Physician's Guide, page 10 and page 11. So let me read a couple of excerpts from the 2016 Physician's Guide, because this is an area where many qualified medical evaluators err, and they provide the wrong analysis on AOE, COE, and they focus their opinion and conclusion on AOE, COE erroneously by focusing on COE when they should put their focus on AOE, okay? So it says, what is a compensable injury? This is page 10 of the 2016 Physician's Guide. It says, an employer must provide compensation without regard to negligence for any injury sustained by his or her employees arising out of and in the course of employment. 4 basic conditions must be met for a workers' compensation claim to be established. Number 1, there must be an injury. Number 2, there must be an employment relationship. Number 3, the injury must have been caused by the employment. This is also referred to as arising out of employment. Number 4, the injury must occur in the course of employment. That is, at the time of the injury, the employee must have been performing a service that grew out of and was incidental to the employment. So on the next page, on page 11, they have an expanded definition of AOE. Okay? It says AOE, arising out of employment. Because the physician provides direct evidence on whether and how the activities of work led to the current injury, the physician answers the question of whether the injury arose out of employment. The physician addresses AOE. What about COE? COE is discussed on page 15. It says, the question of whether an injury occurred in the course of employment is not a medical question because it involves the circumstances of the accident or exposure. If COE is in dispute, a workers' compensation judge will decide the issue based on evidence offered by the employee, the employer, or other witnesses, and on legal precedents. A physician's only input is information that helps to establish the facts of the exposure. So many times a physician errs in his AOE COE determination by providing an argument on COE when the physician needs to focus his argument on the details associated with AOE. So AOE has to do with the medical condition and whether or not the medical condition arose out of the employment. So let's talk about some considerations that make up the AOE COE determination. Remember that COE refers to course of employment, and COE is decided by the judge. It cannot be decided by the QME because the QME was not there to witness the incident of injury. So here are some COE considerations. COE, occurring in the course of employment. These are details that involve the circumstances of the accident or the exposure. Well, witnessed incident is a COE determination. Was there a witness present during the occurrence of the industrial injury? That is a fact that involves the circumstances of the accident or exposure. Those considerations are decided by the judge, are not decided by the qualified medical evaluator. When was the incident reported? Was it timely reported? Was there a delay in reporting? This is a COE consideration. Other legal issues involved with the claim, such as was it a post-termination claim? Was the employee the initial physical aggressor? These are COE considerations. And many times, qualified medical evaluators will fashion their opinion and conclusion on AOE COE by focusing on the COE considerations. And I just spoke to QME the other day who felt that he wrote a fabulous argument against industrial causation, wherein the judge overruled the QME's opinion. And by close analysis of the QME's argument on AOE COE, I concluded that the judge did not uphold the QME's determination because the QME based all of his opinions and conclusions on COE considerations and not on AOE considerations. Well, a couple principal questions involved with AOE, okay? Number one, this is the whole role of the qualified medical evaluator in these denied cases where an AOE COE determination is required. These are cases that we're getting under Labor Code 4060, the compensability exam. So what is the role of the qualified medical evaluator in these cases? Well, here it is. Here it is. It's to provide a compelling argument either for or against industrial injury by focusing on AOE considerations. So consideration numero uno, number one, the big daddy. Does the examinee present with a bona fide symptomatic condition that rises to the level of an injury? Does the examinee actually have a bona fide condition? The best way to deny industrial injury is to find no condition. What if the examinee shows up and they don't have any condition? They have a normal physical exam. Game over. Case closed. No industrial injury if the examinee does not truly have a bona fide symptomatic condition. Now, most examinees, when they show up to the evaluation, they do have bona fide symptomatic conditions. Not always is that condition due to the industrial injury. This raises the whole concept of false imputation. But don't be confused when examinees show up to the evaluation with a bona fide symptomatic condition, because they will. They will have symptomatic conditions. Once you identify that a bona fide symptomatic condition exists, then you then move on to your second consideration. Number two, is it reasonably medically probable that the workplace activities, the way that the examinee described them to have occurred, could have contributed? They don't have to be the sole cause. They simply have to contribute to a significant degree. Could have contributed to a significant degree to the condition that the examinee presents with. So number one, does the examinee have a bona fide symptomatic condition that rises to the level of the injury? If they do, is it reasonably medically probable that the workplace activities could have contributed to a significant degree to that condition? On page 11 of the AMA guides, it states that medically or scientifically based causation requires a detailed analysis of whether the factor could have caused the condition based on scientific evidence and specifically on experienced judgment. So let's review some AOE considerations. Number one, is there a bona fide symptomatic condition present? Number two, what was the mechanism of injury? Was the mechanism of injury mild, moderate, or severe? And is the mechanism of injury consistent with the bona fide condition that you identified? Did the examinee promptly request medical treatment the way any other reasonable person would? Remember, a reasonable person would request medical treatment reasonably proximate to an industrial injury if an industrial injury occurred the way that they described it to have occurred. Has the examinee promptly recovered from the condition due to time and treatment? Or on the other hand, does the examinee have a delayed recovery despite time and despite appropriate medical treatment? In other words, most medical conditions have a natural history, and they do respond to time and they do respond to treatment. So if you have an examinee who is not responding to time and is not responding to appropriate medical treatment, it's highly likely that that medical condition has some other cause than the industrial exposure as it was described by the examinee. Does the medical condition show reversibility? Many conditions will improve when the injurious exposure is removed, and this especially applies to cases of repetitive or cumulative trauma. When you remove the examinee from the circumstance or the environment of repetitive trauma, such as over the weekend or such as over the course of vacations or holidays, most medical conditions will show some reversibility and will improve. If you have an examinee who is showing lack of reversibility of their medical condition, it's reasonably medically probable that that condition is due to some other cause, than the injurious exposure, the way they described it to have occurred. Lack of recovery from uncomplicated medical conditions usually follows a natural course, usually follows a natural history. Most uncomplicated conditions will respond to time and treatment. If the examinee presents with a lack of recovery, it's reasonably medically probable that that medical condition has some other cause than the industrial exposure. So when you write up your argument for or against industrial causation, it's important that you fashion your argument by focusing on the components of the case that revolve around the AOE considerations versus the COE considerations. And if you fashion your argument simply based upon the circumstances of the injury and other legal considerations such as post-termination claims or other Labor Code 3600 considerations such as initial physical aggressor, such as showing up to work intoxicated or under the influence of drugs, those are COE considerations, and those are the considerations that are the concern of the trier of fact, whereas the medical concerns and the medical considerations involve the circumstances involving AOE arising out of employment. The primary ones, again, to reiterate, being number one, is there a bona fide medical condition present? A bona fide symptomatic medical condition present? And if so, is it reasonably medically probable that that condition could have occurred or could have been contributed to a significant degree by the workplace activities, the way the examinee described them to have occurred? And if you're not convinced that your examinee is a credible historian, you simply provide an argument against industrial causation by focusing on the AOE aspects of the claim. If you're convinced that the examinee is a credible historian, then you can support their claim for industrial injury, and you do it again by focusing on the AOE considerations and leaving the COE considerations to the trier of fact, which is the judge. So doctors, I know this is a lot of material, and we're trying to condense a very difficult subject into a system that you can use on your very next examinee. Now, doctors tell me that the AOE-COE consideration, the AOE-COE determination, is the most difficult decision-making that they're tasked with, and I agree. And it's important that we make a correct and accurate determination on AOE-COE in every single case, because we certainly want to provide benefits to injured workers who truly deserve those benefits, but we don't want to provide benefits to claimants who do not qualify for those benefits. So the AOE-COE determination is critical. And here we provide an exact system that you can use to help you arrive at this difficult determination. Simply go through the steps of assessing the examinee's credibility. Once you have assessed the examinee's credibility, you fashion your opinions and conclusions within the body of your report by focusing on the AOE considerations. So doctors, I hope this helps you. This is a system that you can use in every single case with every single examinee. Now, in our next session, we're going to talk about your permanent impairment ratings and how to provide permanent impairment ratings that are true and that are accurate and are a true and accurate description of the examinee's condition at the permanent and stationary evaluation. So for now, I want to conclude today by letting you know this is Dr. Perry Carpenter. I want to thank you for taking the time to join me on today's video. Look forward to being with you on our very next video as we continue our ongoing series entitled The QME's Financial Impact. And for now, I'm wishing you best of success in your career as a qualified medical evaluator.